Securing business longevity. The essential role of legal planning for owners. The entrepreneurial journey is one of vision, dedication, and relentless effort. Yet, the very foundation of a business can be shaken by unforeseen personal circumstances affecting its owners, such as illness or death, or by broader economic adversities. To navigate these turbulent waters and ensure a business not only survives but thrives, proactive legal planning is not merely advisable, but essential. While a business entity itself cannot possess personal legal instruments like a will or a lasting power of attorney, LPA, the diligent use of these tools by its owners, complemented by robust internal agreements and strategic foresight, forms the bedrock of sustainable business continuity. At the forefront of an owner's personal toolkit are two critical instruments: the lasting power of attorney for business affairs and a comprehensive will. A business LPA empowers a business owner, whether a sole trader, partner, or company director, to appoint a trusted individual to make crucial business decisions should they lose mental capacity or become temporarily unavailable. The absence of such a provision can lead to dire consequences: frozen bank accounts, an inability to meet financial obligations to staff and suppliers, and ultimately, operational paralysis. The alternative, an application to the Court of Protection for a deputyship, is often a slow, costly, and uncertain process, which may not result in the appointment of an individual the owner would have chosen. This makes a business LPA particularly indispensable for sole traders, whose business is legally indistinguishable from themselves, and highly recommended for partners and company directors, especially where partnership agreements or articles of association do not adequately address incapacity. Prudent advice often suggests maintaining separate LPAs for personal and business matters to prevent conflicts of interest and ensure decisions are made with the requisite expertise. Complementing the LPA, a meticulously drafted will is paramount for dictating the future of a business owner's interests upon their death. Without a will, business assets are distributed according to the rigid rules of intestacy, which may starkly contrast with the owner's wishes or the operational needs of the business. This can ignite disputes among potential heirs, disrupt operations, and, in worst-case scenarios, force the sale or closure of the enterprise. For businesses with multiple owners, it is crucial that individual wills are harmonized with existing partnership agreements or company articles of association, ensuring a clear and agreed-upon succession mechanism. Beyond these personal legal instruments, a broader framework of legal strategies is vital for comprehensive business resilience. For companies with multiple shareholders, a comprehensive shareholder agreement serves as a foundational document. It governs the intricate relationships between shareholders and, critically, outlines procedures for various contingencies. Key provisions within such agreements include buy-sell clauses, which dictate the handling of a departing shareholder's shares, ensuring they do not fall into unintended hands and providing liquidity. Rights of first refusal or offer give existing shareholders priority in acquiring shares, while drag-along and tag-along rights manage the dynamics of company sales, protecting both majority and minority interests. Incapacity clauses and clear dispute resolution mechanisms further preempt potential deadlocks. Cross-option agreements, often funded by life insurance, provide a structured way for surviving shareholders to purchase a deceased owner's shares, ensuring a smooth transition. Key person insurance offers another layer of financial protection. This is a life or critical illness policy taken out by the business on an individual whose incapacitation or death would significantly impact operations and profitability. The business, as the beneficiary, can use the payout to fund buy-sell agreements, cover lost profits, finance the recruitment and training of a replacement, or reassure stakeholders during a period of uncertainty. These specific instruments are best utilized within a wider strategy of business succession planning. This involves the proactive identification and development of future leaders and owners. Effective succession plans are deeply integrated with shareholder agreements and the personal estate planning of the owners, including their wills and any trusts they may establish. Trusts, for instance, can be a sophisticated vehicle for holding shares for beneficiaries while ensuring professional management or a controlled transition of ownership. The very structure and governance documents of the business, such as the articles of association for a company or a partnership agreement, also play a crucial role. These documents can and should include provisions for managing a director's or partner's incapacity and outline clear processes for share transfers and decision-making in critical scenarios. Even contingency planning for economic hardship, through mechanisms like well-drafted force majeure clauses in contracts, appropriate business interruption insurance, and robust financial and operational planning, contributes significantly to long-term stability. Implementing these multifaceted legal protections requires a proactive and diligent approach. The first and most crucial step is to seek professional legal and financial advice tailored to the specific needs of the business and its owners. Open communication among all stakeholders, particularly co-owners, is essential to agree on a cohesive plan. Furthermore, these legal arrangements are not static. They must be regularly reviewed and updated, ideally every few years or in response to significant business or personal changes, to remain effective. Finally, meticulous and proper documentation, ensuring all agreements are correctly drafted, signed, and securely stored, is imperative. In conclusion, safeguarding a business against the unforeseen is an act of responsible stewardship. The strategic implementation of personal legal tools like wills and business LPAs by owners, coupled with comprehensive shareholder agreements, key person insurance, and diligent succession planning, does not signify pessimism. Instead, it demonstrates a commitment to the business's longevity, the protection of its value, and the security of all its stakeholders, family, employees, and customers alike. By addressing these legal avenues today, business owners can build a more resilient enterprise, capable of weathering storms and securing its legacy for the future. For advice and assistance, contact Tan Law Solicitors on info@tanlaw.co.uk or call 0247 763 2323.